She's good people.
All right. So the next item on our agenda tonight are reports and updates. So first you get to hear from me. Our goal for tonight, and I think hopefully everybody knows this, is to get through all of our second readings. The idea is if we can get through our second readings tonight, that will set us up for our activity or our exercise on Wednesday. Hopefully commissioners are aware, because I mentioned this in an email yesterday, but on Wednesday our plan is to have all of the amendments that have been put into the hopper, so all of the proposals that are up for final consideration, physically up on the wall so we can see all of them. And then each commissioner is going to get 10 red dots to be able, or I don't have color there. Blue. 10 blue dots. To put on the proposals that they think are the most important to be able to move onto the ballot. That way we can get a visual representation of the proposals that have the most support, as a way to understand where our work needs to go from here. We'll also be able to see them by their article to see if there are any potentials for combining proposals, just to be able to actually see it all. Because right now we have quite a few proposals, and depending on how many we move forward tonight, we might have more, and we can't send them all to the ballot. So we really need to find a way to combine or eliminate some of the proposals from that final consideration. For any commissioners that will be virtual, we will send you a PDF of exactly what's on the wall, and you'll need to let the clerk know where to put your dots. We'll have a different clerk. Katie won't be with us on Wednesday. We'll have Audrey here, so we'll make sure you have the contact information there. All right. I think those were the pieces, unless there are just real quick questions. Commissioner Hetherington, looks like you have a question for me.
I guess just a point of clarification for the agenda. If we do get through this for the agenda on Wednesday, then is there a set deal that we're going to do after that exercise? Are we going to prioritize based on, how will the agenda read for the public, I guess?
Sure. So the agenda will just be the activity. We could take action from there based on the activity, but that is what the agenda will read. And then, Vice Chair Rhodes, did you have?
If the intent, as the chair said, is to get a representation of how we might proceed with the next body of work, we will have to take action as a body to agree how that's going to happen. And we will write the agenda with some flexibility, so if we finish that exercise and we have a sense of where we want to go, we can take votes on it.
Commissioner Rourke?
Commissioner Roar, District 6. I have a question about what our plan is. I know that there's been talk about a Saturday meeting. I just wanted to state for the record, it would be, it would be my preference that we work as late as we can this evening and as late as we can Wednesday. I am not available over the weekend, and I would want to be a part of the process, and this is kind of our own doing why we are here right now. And so if we need to go through all these proposals, then I think the burden lies on us to kind of get it done and be reasonable and fair to every commissioner who's been serving and giving up their time. I mean, I know I can share personally just the hours I prepare before a meeting, and we just need to do our best to honor everyone's time. So, especially right now. Thanks.
Commissioner Rogie?
Thank you, Madam Chair. Commissioner Rogie, District 3. I agree with Commissioner Rohr. I am not available on the weekends, and I have several family commitments that I have made. and so I will not be available, and I've been at all the meetings in person. So I do not want to break that streak because I am committed to serving my community and speaking on behalf of them. So I like the idea, although I don't want to get unrealistic and be here until 1 o'clock in the morning tonight. We did add extra meetings for this very purpose, so we have Monday and Wednesday. And I would highly recommend that we use the next 2 meetings to get through the second readings, and then we can go through our activity Wednesday. Thank you.
So just a point of clarification, we actually, in our process, have stated that we will have 2 full meetings of looking at just the proposals that are up for final consideration. And so to be able to do that, we actually need to be done with second readings and be done with our activity by the end of Wednesday. So there isn't actually additional wiggle room, depending on how much we are able to get done tonight. Commissioner Boyd?
This is going to be ironic because I'm giving more statement time to this, but I do want to say we have an obligation to be talking with brevity when we are done. And there's no reason why we can't send something out ahead of time to say, here's my thoughts. If they're going to be very, very lengthy, this is almost like filibustering. It feels like we are talking for long, long periods of time and reading long, long written statements, and I think that is taking up the majority of our time. And we saw on social media that that's the same thing that is being asked of the public to do, to come and waste our time so we can't move forward.
Commissioner Randall Kelly?
Thank you, Commissioner Randall Kelly, District 4. I will keep this very brief as well. I fully agree with everything said by Commissioner Boyd. I also think that we should fully commit to getting through second reading tonight and be here as late as we need to be here. And if we're going to say we want the weekend off, then we have to also be committed to getting the work done tonight.
Commissioner Layton?
Thank you, Madam Chair, Commissioner Layton, District 7. I just want to point out in our rules on number 19, it just says 2 consecutive meetings will be scheduled to take public comment on the and continue discussion of proposals that have been advanced to final consideration. Public comment can be taken on Wednesday on our final, if we get through it all, that counts as 1, and 2 would be next Monday, because it also says proposed revisions to amendments advanced for final consideration when presented to the Commission at the meetings following the second reading, second public comment meeting, but no later than June 15th. So we're on our own deadline here. I would count Wednesday as a public comment time and discussion of this body, and I think that once we're done with our exercise, we can take a few more than a 10-minute break and reorganize ourselves and then continue with our meeting. And brevity is really awesome.
Commissioner Rohr?
Commissioner Rohr, District 6. I'm going to disagree with some of my commissioners this evening with what's been framed as filibustering. We have barely spent time on proposals, and we should all get a time to speak to them. It is offensive that you don't want to have public comment from your fellow commissioners to try and improve a proposal, or for commissioners to understand and move proposals or not move proposals. It is important to the public process. It is needed. And a commissioner should be able to take up to 10 minutes. And most people aren't doing that. Thank you.
Commissioner Roby?
Commissioner Roby, District 3. I am in agreement again with Commissioner Rohr. I am too offended because we have not gone outside of our process that we developed from the very beginning, where we said that the commissioners have 10 minutes to speak to these proposals. And I'm representing my community, and I am getting feedback from the community thanking me for representing them well. So I don't appreciate this continuous comment about keep it brief, keep it brief. Well, you know what? I wasn't the one who made 45 proposals. So if we have 45 proposals, I'm going to speak on behalf of my community, and I'm going to do my research and I'm going to speak because the public depends on us to represent them. So I too am offended by that comment, and I think we listened. There was a commissioner last week, the last week or the week before, that took 15 minutes, and it was a rebuttal. So it was not me. So, and I don't think any of us have taken more than 10 minutes. So I would appreciate it if we would just stick to the process and quit making comments like we're going outside of that. Thank you.
Commissioner Hammack?
Commissioner Hannick, first district. I am just feel a little challenged this time when we're told that we only have 2 times to talk. It is in the discussion of back and forth. We have another opinion from another side, and then we have a chance to digest that and then comment on that. It is that kind of robust discussion, back and forth, that creates to a good final decision when it comes to the ballot measure. When we're allowed to say some words just on our own side, while we're coming out the cage and saying something, and then we get another person saying something, and then we don't have a chance to respond or to digest what was said and comment on the good and the bad. That's what makes the good discussion on what we are doing, not just cutting short our conversations. So I do appreciate when we have a chance to go back and forth and have more discussion. And just wanted to say that. And sometimes it may sound to you like a filibustering because we're rattling off all kinds of facts. It's kind of like we're boxed in and we only feel that we have one shot at it. So we come out and say everything at one time, knowing that we may never have a second chance. So just want to comment on that.
Commissioner Liggins?
Thank you, Madam Chair. I'll keep my comments very brief. I just want to say that in the last few commission meetings, I've been discouraged by some of the personal characterizations and the temperament within this council, within this commission. I think we all are very passionate. I think we all care deeply about the community, and I think we're all kind of policy nerds and diving deep into this. But I feel like it's gotten into character disparagement, into critical accusations, and quite frankly, name-calling that kind of puts me at a loss. And I think that respectfully disagreeing is a really important part of democracy, and I just challenge us all to come to that and to get along and bring our best selves to this discussion. We're going to disagree on policy, absolutely. But we should try to be respectful of the process. And whatever makes it through the hopper, whether I voted for it or not, doesn't matter. What I need to believe in is the process. And I think we should all remember why we're here. Thank you.
All right, so thank you everyone for the discussion around what our next steps will look like. So I don't believe we have any legal report for this evening. So that moves us on to amendment proposals. We're gonna, like I said, just talk about second readings. When we are talking about second readings, we need to have folks start with a motion so that we are taking action. And when that happens, the maker of the motion has the first chance to speak on the motion, as with any other motion. And then it's open to the floor for amendments or to that proposal. And then we will vote on whether or not it will move on because it will be a motion. Because it is a motion, then each person does have the opportunity to speak twice for up to 10 minutes. I do want to recognize that we have a lot of proposals to get through tonight, so being thoughtful about that is, I think, helpful for everyone to be able to stay present and aware. I know I've looked around this room sometimes at 10:30 and seeing a lot of folks feel pretty tired, and that means that at the end we aren't giving those proposals the same level of engagement. And so I want to make sure that we have the opportunity to do that tonight. All right, with that, we are going to move on to C26, which which is community stewardship on page 44 of your packet. Commissioner Strickling, do you have a motion?
I would like to make a motion to move this to the hopper.
So we have a motion to move C26, community stewardship, to the hopper. Do I have a second? Seeing no second, unfortunately that motion fails. So that moves us on to C27, housing stability, on page 48 of your packet. Commissioner Strickland, do you have a motion?
I have a motion to move this, but I also amend as amended, and I don't know, Jake, you got?
You do the motion first, and then we'll.
Okay, I'm making the motion.
Seconded.
And second from Commissioner Hunter. So that will bring us on to discussion, where the motion seeker does have the opportunity to speak first. And then amendment can absolutely be offered. Commissioner Hunter.
Permission for that.
Thank you, Madam Chair. I would like to move to amend this proposal as listed in the packet. I don't know what page it's on.
It's on page 52.
I would like to note that we're missing an "and" at the end, a comma "and."
Which one? I don't know, but I missed it.
What?
So can you tell us the motion? Or the amendment?
I would like to move to amend the proposal as written on page 52 of our packet. Would you like me to read it into the record?
Yes.
Strike all the language that exists and add, there is hereby created the Department of Housing Stability. The department shall administer programs and enforce ordinances relating to matters including, but not limited to manufactured housing, communities, housing stability, affordable housing preservation, displacement prevention, tenant protections, and relocation assistance.
All right, so we have a motion to amend C27 to the language on page 52 of the packet. Do I have a second? Second from Commissioner Strickling. So discussion on just the amendment. So just the languages in your packet on page 52. And Commissioner Hunter, you get to speak to that first.
Thank you, Madam Chair. I think that this amendment empowers the council to enact all of the changes initially proposed by Commissioner Strickling, but not encapsulating it in law for 10 years, making it more nimble so they can adjust as needed, and perhaps spend more time deciding what actually needs to happen in regards to this.
All right, additional discussion on the amendment. Commissioner Strickling?
Yeah, I just wanted to add that, like, in the spirit, I'd really like to encourage the council to take into effect and look deeply at the previous amendment for guidance to move that forward. Also, it was interesting seeing a lot of lobbyists in the beginning who make ridiculous amounts of money, tell a bunch of people about policies that, you know, you're looking at someone who makes $18,000 a month right now that came in and spoke to us. So just doing lobbying work. So I think that's really interesting when you've got families that are making, you know, living on Social Security, making close to just about $2,000 a month, depending from their Social Security, and those are the people that will be losing their housing. So keeping that framing in mind when you're thinking about how we can be accountable to the folks that live in our county and not the ones that don't actually live here and are making a small fortune. Thank you.
Commissioner Roby?
Commissioner Roby, District 3. Once again, another proposal that adds a department to Pierce County and gives executive authority over yet another area. The funny thing is the executive and the council already have this ability to create, if they wanted to, a Department of Housing Stability and Manufactured Housing Community Protections. We have protections under the code. They have the authority to create a department should they need it. They can do it through the budget. They can listen to the community if it's something that's needed. Of course we want to protect housing, but the charter is not a place to solidify a department with no fiscal note and no sustainable funding source for the next 10 years. And this is like the sixth or seventh new department in our proposal. So I just want us to keep that in mind in a time where we're having some serious budgetary issues in the county and hiring freezes. And we're just growing government. Thank you.
Commissioner Rohr. All right. Commissioner Malowski.
Thank you, Madam Chair. We had a lot of references in regards to this proposal. The thing is that I was going to deal with the ones that came to the public comment, but I didn't know they were going to attend tonight's meeting. But the thing is that the RCW and different laws and things have been in place to help improve the housing, especially the mobile home parks. The thing is that they have improved a lot in regards to the rental. They put a cap on that so that the rent will not increase. I really feel that this does not belong in the charter. It adds more strenuous restrictions for the tenant, let alone the homeowner from here. Just by capping the rent does not alleviate the problem, because then we created another problem where the homeowner itself can't maintain the property of value so that that person can stay in that property. The other thing is they mentioned
Commissioner
about
Malowski, is
the
this
senior.
about the amendment? The amended language that's in the packet?
Yes.
Okay.
Thank you so much for reminding me. The thing is, with that amendment, it will not fit, all right, for the charter. It creates restrictions that's going to be a burden not just on the tenant, but also on the homeowner. And also, it does not provide or alleviate in regards to providing more homes or to find places to transmit people who might be losing their homes. So I really don't think that this is going to be a fit. I would, if it's possible, Madam Chair, educate me, but I would love to make a motion for this proposal not to even be considered.
So we are currently in the process of an amendment to this specific proposal. I don't believe we can withdraw it at this point. So we will just continue on with discussion of this amendment to the proposal. Vice Chair Lentz?
I just want to say that I've been entirely consistent about voting yes on amendments that sponsoring commissioners offer. I intend to vote yes on this. It's the sponsoring commissioner's intention to amend their proposal, as everyone else has had the opportunity to do. However, I am going to be voting no on the underlying proposal, and I wanted to get that out right now.
Commissioner Riddle Kelly?
Thank you, Commissioner Riddle Kelly, District 4. I'm going to keep this really quick because it seems to be some confusion among some of our colleagues about the amendment or the underlying amendment. I am in favor of the amendment and will offer additional comments about the underlying amendment once the amendment goes through.
Commissioner Yannick?
Commissioner Hannick, District 1. As I look at some of the details, it's going to apply to certain people, but it's not limited to. It still doesn't give a lot of definitions, except that it's going to create a new department. Then the department will be the one that creates the details of what is defined. And I'm not sure that this body is ready to give that kind of a blank check to another department yet to be created so that they can go spend the taxpayer dollars for a small segment of the population. Although there is a need, although I can understand, and I know what it's like to be a senior on low income and, you know, watching my parents have been that way, I still say that this is not just helping all the residents of Pierce County, but a certain specific set of population that needs help, but this is not the way to do it, the help, by making a department like this at such a time as we have now. So I'll be voting no on the amendment and the underlying item as well.
Commissioner Consuelo?
Thank you, Madam Chair. Commissioner Consuelo, District 7. The way I'm reading this amendment is to include, at least hopefully, more folks. I'm seeing displacement prevention, relocation assistance, affordable housing preservation, working with our homeless population, our folks that are unhoused. I believe this could fit well into that. An original intention for me and something that I wanted to support and at the beginning of this process was an amendment for our unhoused population, for our unhoused neighbors. And so I think if I'm reading this correctly, I think that could include that portion of our population. We're currently, I believe, around, from the last point in time count, around 2,500 folks in Pierce County are facing homelessness. So I think that this would be a good and inclusive amendment to go beyond the scope of just our folks who need assistance in our manufactured housing communities, but to expand to that extent. I don't know if there's already something under Human Services or something that does this, but yeah, thank you.
Commissioner Rohr?
Commissioner Rohr, District 6. And I'll just speak really quickly to the point in time count, or just county, how much the county has invested in bringing solutions to homelessness and housing. I think in the past decade, we've doubled, tripled probably the amount that we are pouring into this challenge that we're seeing in our communities. I'm quite confident of that number, that we're probably like in the $30 million price tag to help and support. And I think the challenge that we've seen in terms of results is that our homelessness has increased. So I don't know that adding a new department is fiscally wise either at this time. So I kind of thought of some questions on the amendment, and I do want to thank the sponsor of the amendment. I think it makes the proposal better. I still believe it does not belong in the charter. It is a housing policy. It is an unfunded mandate, and I don't know if you've looked at our county's budget and what our county is facing in the next 6-year outlook. We are at we reach zero in terms of what's in our funds for operating. And this is not the time to be putting such a amendment into the charter. It definitely deserves a robust debate in county council. But Pierce County executive departments already have, may have already established these Pierce County executive departments may already be established by ordinance. What specifically requires the creation of a housing stability department in the charter rather than through an ordinance adopted by the county council. What analysis has been completed to establish the county's existing organizational structure is inadequate, where the county executive, human services, planning and public works, prosecuting attorney consulted before proposing a separate department. Human services already administers housing-related programs and resources. Which existing programs, staff programs, funding sources, and responsibilities would be transferred to the new department, and which would remain with the human services or other departments? The amendment requires the department to administer programs and enforce ordinances relating to matters including but not limited to housing stability, affordable housing preservation, tenant protections, displacement prevention, and relocation assistance. What limits the scope of this department, and what additional responsibilities would be added without another vote of the people. What ordinances would this department enforce, and what legally would support the enforcement? What legal authority would? Has the prosecuting attorney reviewed the replacement language for possible conflicts with state law or limits on county authority? Has a fiscal or operational analysis been completed? What are the estimated startup and ongoing costs for staffing, administration, legal support, enforcement, technology, office space, program delivery, and what funding is anticipated? If a future council or executive concluded that these responsibilities should be consolidated with human services or organized differently, could they restructure or eliminate this department without another charter amendment? Why should one specific administrative structure be permanently placed in the charter? And I'll save some for closing statement, but I'm uncertain how to proceed because I do support that you cleaned up the proposal. So, thank you.
Commissioner Fletcher?
Commissioner Fletcher, District 5. I do appreciate this amendment insofar as the additional effort that went into cleaning up the language, making it digestible for the commission, for the public. But insofar as this amendment contains the same flaws that the original one did, namely that it's beyond the scope of this commission and has no business being in the charter. Like we've heard before, council wants to, they can do it. I don't think there's been a business case made for this yet today. Haven't heard it yet. Maybe we will hear it tonight. But, and again, this is already contemplated in the RCW, so I do appreciate this amendment for making the proposal really bring forth the key aspects of it. Unfortunately, those key aspects are all troubling as they seek to enter into the charter. So I will not be supporting the underlying, but the work for this amended proposal is noted and appreciated.
Commissioner Liggins?
Thank you, Madam Chair. I just want to concur with both Commissioner Fletcher and Commissioner Lance in that I appreciate the work that has gone into this amendment. I will be supporting the amendment, and will save my comments for the general discussion.
Seeing no additional discussion, we will now take a vote on the amendment, not the underlying proposal as a whole, but just on the amendment language. So, all in favor of the amendment to C27 that's listed on page 52 of your packet, please raise your cards. Count 13. All opposed, please raise your cards. Six. And then no abstentions. Or one abstention. Thank you. So that's 13 in favor, 6 opposed, and 1 abstention. All right, so that brings us back to, so now that passes, and that brings us to the C27 as amended. So discussion on C27 as amended. Commissioner O'Leary?
Thank you, Commissioner O'Leary, District 1. I can appreciate the overall approach to this, the portion of our society that is really struggling. But I do not feel this belongs in the charter. I think that it's much better served if it were to be put in place at the county level through ordinance of some kind. And that would allow more flexibility. I'm also extremely concerned about the fiscal issues that this brings by creating another department. And I think we have a responsibility to our budget, to our citizens, to our individual districts, to be cognizant of that with each and every one of these that we are considering throughout the balance of our process. So I will be a no vote on this. I do appreciate the overall sentiment of it, but I think it's better handled in another arena. Thank you.
Commissioner Molesky?
Thank you, Madam Chair. Once again, I really appreciate the proposal because it's deep to my heart. It's one of those things that I advocate for years. But it doesn't solve the issue. It's like a tennis court. If we put restrictions on the landlord or the property owner, then the tenant feels the pressure. If we make things as benefit for the tenant, and the landlord feels the pressure. So nobody's really winning on this side of the house. May I provide an example? It took me 6 attempts to help house a senior who was displaced from her home. The one thing I saw that was consistent is the policies and laws in regards to housing. I took her to the low-income housing. She's on Social Security only. And it surprised me to know that the restriction is she has to make 1.5 to 2 times the income to even qualify for an application. That blew my mind, all right, for a low-income housing, let alone the regular housing. Now, when I tried to find an apartment, like I said, it took me 6 times for property management to even approve, because they would not consider the money that she was receiving from her home, because we had to do a short sale on her home, in addition to her Social Security. I figured that combining that would make her qualified to be considered because of the restriction requirement of how much she's supposed to have for income. Only one, which was out of 5. The thing is, a person's savings cannot be identified or used as a income base requirement. And that just blew my mind as well. So the thing is, it's not much that we don't have enough housing. It's just we need to look at the policies that has been set, all right, to be withheld. And the only way that can be possible is maybe through the council or through the housing authority. That's why I really believe that this proposal would not benefit being in the charter, because it will not alleviate the problem. It would just increase it. And so I would be a no to this proposal. Thank you.
Commissioner Likens?
Thank you, Madam Chair. I just want to echo the sentiments that many commissioners have brought up, in that I appreciate the compassion that we are all showing to the originators and the intent of this legislation. I think it's an important thing. It's something we ran into in the city of Gig Harbor and had to come up with some creative options in order to maintain the housing parks for our residents who are utilizing them. That being said, there are excellent resources through the Department of Commerce in their manufacturing housing work plan ideas that was published in 2025, as well as MRSC has many things that jurisdictions are able to do, everything from manufactured housing only zoning to repurchasing plans to self-purchasing plans, and I know that Kitsap and I believe Snohomish County have both enacted those. I think this is more appropriate at the ordinance level and something that council could consider and deliberate. But when we put things in the charter, we should be focusing on the structures and makeup of our county government and the necessary checks and balances. And this, like many of the policies that you will see coming before us tonight, I also won't be supporting, because I believe they can be accomplished through the legislative process within the county. Thank you.
Commissioner Rogie? Thank you, Madam Chair. Commissioner Rogie, District 3. I concur with much of what is said today, including Commissioner Likens. We are not legislators. We are charter commissioners who need to focus on the structure and authority of government. So I believe that this proposal, well, there's just a reason why we don't do legislation here. We have 6 months. We don't have time to debate whether this is in conflict with the law or not. We don't have a thorough legal review or analysis. We don't have a fiscal note. Pierce County has invested $17 million in affordable housing. The RCW covers rents, rights, attorneys, fees, duties, landlord-tenant rules. We have Pierce County Code Title 18A 65 affordable housing incentives. So we have programs for these types of issues. And I want to support the community who needs these. And I think it is better served by the executive and the council to initiate a program and policy around these issues, which they have. And I think it's a pretty robust program where we are trying to solve the affordable housing problem. Pierce County Landlord Tenant page provides resources, and also the Pierce County Affordable Housing website explains funding, projects, and resources. So this proposal is not new ideas. And there are resources throughout the county, and it should not be in the charter. So I am a no, and I'm hoping that my commissioners will also vote no, and we can get focused on what should be in the charter. Thank you.
Commissioner Willis?
Hi, Commissioner Willis, District 3, appreciate it. Madam Chair, excuse me. A couple comments that I wanted to make. First and foremost, I built homes in Pierce County, Thurston County, King County, Kitsap County, mainly new construction for 12 years, did land development, and I'd always argued that there's no such thing as affordable new housing. It just doesn't exist in the state. I've testified to BIW, the Business Industry Association of Washington. I've testified to the local master builders to help cut a lot of red tape out of new housing. It just doesn't happen overnight. So I took to an advisory board with the Southtown Housing Affordability SHAPE, which I was awesomely selected to serve as co-chair for. And that was my first real insight into the housing displacement issues in Pierce County, because I just didn't know. I was building homes for people on custom land. So it was interesting, but I also saw and worked with a lot of council members that are really actually good at solving problems. And speaking with several of them, I have learned that they've actually solved quite a few problems. One through the Maureen Howard Affordable Housing Act, passed in 2023, which funded affordable housing production and preservation. The council also approved housing investments through the Housing and Related Services Fund, which provided affordability, supportive housing, anti-displacement, and keeping residents in their communities. And then council advanced temporary housing communities legislation to remove code barriers for temporary sheltering and in unincorporated areas. Excuse me. So my point is that the council members are doing really good work. I think they can continue to do work, and I know I've said this before early on, but I do believe this has a bit of policy creep to it. I can definitely appreciate the amendment, or proposal rather, and I do think that this is an extremely important issue, but I just don't believe, as many commissioners have said, this belongs in the charter, and I do believe that council, if we put enough pressure on them, I think they can figure this out at the local legislative level. Thank you.
Commissioner Heatherington?
Thank you, Chair. Commissioner Heatherington, District 2. So, yeah, over the weekend and this morning I went back and looked at a lot of the different amendments we put forward, what's already in the hopper and what we're tasking with tonight. And I probably will only speak once, maybe twice tonight because I want to get it all out. But we bit off a lot. We bit off an extremely, way too much stuff. And, you know, this is one of those things that while I appreciated it, you know, I do think I don't think it belongs in a charter. I mean, I know we're all passionate at this table about different subjects and everything else, and I look back at, you know, something that I proposed, C12, that I realized right out of the gate that it was more of a policy issue, and I continue to work with my brothers and sisters in the labor movement, with the executive and with this office on, you know, that C12 amendment that I put forward. We're making good progress there. Jerome, C22, I'm very, very passionate about that thing, but I think that's something that we can fix in policy and do with, and make those adjustments at the council level. So I just think that, you know, we have to adjust what we want to put to the public and not cause voter fatigue, or make sure that we're putting to the public the things that they're going to that we're all in agreement with, or maybe even the majority with, that the public can vote on. So unfortunately, I will not be voting for this. Thank you.
Commissioner Randall Kelly?
Thank you, Madam Chair. Commissioner Randall Kelly, District 4. Just one quick comment before a bit of advocacy here. I think we need to remember that just because certain things aren't in this charter historically doesn't mean they're not in charters. And the creation of offices, departments, and commissions is something that is subject that charters can control and do frequently do in different jurisdictions throughout the country. So I think that you can make an argument if you want that this charter shouldn't have it, but to act as if charters don't have that, I think is erroneous. It's interesting because I work in housing justice. I've worked in housing justice for many years as a volunteer and more recently as staff. And I work closely with most of, if not all of, the organizations and policies listed in the last several minutes by people that I think are somewhat unfamiliar with them. And I will say that a lot of them are well-intended, a lot of them are good, a lot of them do a great job, and a lot of them don't go far enough. I would also add that part of some of the great legislation to come out of the state over the last couple of years, both with rent stabilization and in particular legislation directed at mobile homes, there's been an emphasis on counties figuring out how to help enforce it, how to help do the work, and direct encouragement from the state legislature because there's only so much they can do when it comes to rulemaking and implementation at the local level. The housing crisis is the most pronounced thing that most people are going through, and it's not just a subset of particularly poor and vulnerable people. The economy is such, and the market around housing is such, that most folks are downwardly mobile. Intergenerational wealth transfer is not really happening anymore in the way it was. And there's folks that are particularly trapped, such as people in mobile home parks and certain types of renters, that you would never expect are the folks that are one paycheck away from losing their house or their apartment or choosing between utilities and food, or utilities and rent. So while this is not something that may conventionally be considered part of a charter, I do think it's important to strongly consider that. I also think it's actually very in line with a couple of my amendments and a couple of amendments I believe are broadly popular here, because we need significant more coordination between different jurisdictions, between different levels of government, and between different agencies on solving one of the most important immediate crises that people are facing today. So I'm a supporter of creating an office. It's not the perfect solution, but I think it's part of the solution. So thank you.
Commissioner Moore?
Commissioner Rohr, District 6. So the question is whether the county charter, our county charter, Pierce County charter, should permanently create a new executive department. And Pierce County already has the authority to create this executive department by ordinance. The county also already it does administer housing-related programs and resources through human services and other existing structures. And I agree there are gaps in our system, and there are people struggling. And I have the opportunity to work at the legislature, and I sit with housing groups, and I listen to these people come in and tell their story of how they don't have money. The park is being sold, and I have an opportunity in my position to advocate for them, and we make sure that we're fighting for them no matter who they are. And so, yes, our government needs to do more or streamline or somehow improve our systems, and that is through the legislative process. So the question that should be addressed through the ordinary legislative and budget process, the council later determines, if the council later determines that a separate department is necessary, it can establish one by ordinance. That approach allows the county to respond to changing housing needs while preserving administrative flexibility. I do not support an undefined, potentially duplicative department permanently in our charter. So I will be voting no on C-27. And I thought it was, one of the public commenters came in and spoke about a state program through our Attorney General's office, which I was actually not aware of until he mentioned it. So I was grateful for the testimony that comes in here, regardless of who it comes from. So the Washington has a manufactured housing dispute resolution program within the Attorney General's office, and it helps manufactured homeowners and park landlords resolve disputes involving alleged violations of the Manufactured Mobile Home Landlord Tenant Act. The Attorney General's office can accept complaints, investigate issues, assist with dispute resolution, and take enforcement action when appropriate. So the county does not need to create a separate charter level department to address the issues that are already regulated and enforced by state law. Thank you.
Mr. Strickland?
Okay, so we have the largest amount of manufactured homes in the state. That's 7,490 households and 165 manufactured homes. So Commissioner Consuelo said earlier that we have 2,500 facing homelessness according to the point in time. If 1/4 of these households are bought up by an equity firm and displaced, we could double the amount of homelessness that is in our streets tomorrow, depending on how things go. So 13.7% of the state is in Pierce County, period. It's not a small amount of people that are facing this. It's not a small problem. It's actually a devastating problem. And we have, in my opinion, we can take bold action and do something about it now. On the other front, we made an amendment to make it more charter-esque, if that's a thing. I don't know, it's funny, because it's like I hear the same comments based off of the old version, not the current version. And I just think you can't win at all in either direction. So, I mean, what is, I don't understand. Somebody explain to me the difference between legislating or putting something in the charter that's structural or something. That would be really useful for me, and it would have been useful months ago, because I feel like when you make it more structural, you create a department so it can handle the things, then that's, that was based off of feedback that we got from this room. So the fact that it switched back, it's a little confusing to me. Also, we had a public commenter here who was a realtor who came and talked about the structural challenges of dealing with just the buying selling side for these folks that are in this room. She's trying to face that and talk to her, she's dealing with things that are, it's not easy. It doesn't make sense. We should be streamlining it and making it make sense. We should be using the government to make the different governments work in a way that makes sense. So whether or not everything that we're doing, I took most of the legislating out of the charter and put it into the actual ordinances, which you guys all asked for. So I did that. Well, technically Jake did that. But, there's been an extreme amount of work that's gone into this. And we're not talking about just knocking doors for my charter commission seat. I've been running into this problem for 5 years on knocking doors and talking to folks. These are real problems that people are really facing. And I don't believe that the AG should be the first point of action to solving this problem. That should be the last point of action to solving this problem. It should be your most tangible, relatable person that you talk to in government. It should be somebody like your council member or something that's not statewide when you're having such a massive issue right here, right now. So, I don't know. I'd say thanks to the people who spoke up for this. I hope that you guys can see value in it and you decide to vote for it. Thank you.
Seeing no additional discussion, the motion that we have before us is to move C27 as amended into the hopper for final consideration. So we'll take a vote, and this is a roll call vote, which is what we've been doing for all second readings. Any questions about that? Seeing none, clerk, can you please call the roll?
Lisa Boyd,
Nay.
George Consuelo,
Aye.
Mason Fletcher,
No.
Kate Kinn,
Aye.
Sharon Hannick,
No.
Caleb Heimlich,
No.
Elizabeth Herrera,
No.
Billy Joe Heatherington,
No.
Jake Hunter,
Aye.
Marvin Lance,
No.
Justin Layton,
No.
Brenda Likens,
No.
Brenda Molesky,
No.
Drew O'Leary,
No.
Holly Rogie,
No.
Rujana Rourke,
No.
Deborah Rydell Kelly,
Aye.
Troy Surratt,
No.
Jen Marie Strickling,
Aye.
Judson Willis,
No.
Kelsey Barnes.
No. I have 5 in favor and 16 opposed. So that motion does not pass, and we will move on to C30, Sheriff Ombuds on page 54 of your packet. Does the sponsoring commissioner have a motion?
Yeah, motion to move C30 to the hopper.
Second.
Motion and seconded. So on to discussion of C30, Sheriff Ombuds on page 54 of your packet. And Keegan, you get to start.
Thank you, Madam Chair. Commissioner again, District 4. Mr. Kinnaman from the State Ombuds Office really said what I would want to say, so I'm not going to repeat it. He knows the value more than I, but I just wanted to reiterate that I really have dived into Ombuds Inspector General's offices a lot over these past few months because I was really curious about the effectiveness in making government work better and be responsive to people, and this is a mechanism that I've had clients use when it comes to ombuds for child welfare services. It's a complaint mechanism for more public responsiveness from a party that's not a party to the case, so it's a neutral party. And in terms of the budget concerns, I just really feel like if done well, ombuds offices are there to improve, to resolve complaints, to avoid litigation, and to save money in the long term. So I ask for your support. Thank you.
So on to discussion of the motion to move C30 on to final consideration. Commissioner Malevsky?
Thank you, Madam Chair. I would not be supporting this proposal for the reason here is one, the law enforcement department of the Pierce County Sheriff's Office, they have different departments that handles these same particular things that we're talking about. Granted, we do need some type of transparency and accountability, but I really believe that we need to educate the community in regards to how using these agencies that already exist that provides equivalent or the same type of services that this proposal is going to offer. I know at the Pierce County Sheriff's Office, they already has established procedures for taking and investigating complaints to include anonymous complaints. The implementation of the BWC has drastically diminished the level of complaints to the Pierce County Sheriff's Office with, well, cameras doesn't exist anymore, but with cameras also coming for the jail. So the Pierce County Sheriff's Office has also renegotiated the standards of conduct and investigate procedures for the Deputy Sheriff Guild, making it more efficient, timeline, and calling for transparency, as well as giving the Sheriff's Office more authority over the use and releases of the BWF footage and increased transparency. Oversight at the cost of millions of dollars per year are not needed nor warranted. So the consequences we're looking at in the Sheriff's Office or Police Department creates an ombudsman with broad subpoena power. The most significant risks are not usually the cost of the ombudsman itself. The larger potential exposures come from constitutional litigations over speech and privacy rights, labor grievances and arbitration, civil rights settlements and attorney fees, challenges to the scope of investigative authority. But we would still need to remember the financial exposure, so if any agency discipline terminates or otherwise penalize officers based on protected speech, it may face a civil rights lawsuit, back pay awards, reinstatement orders, attorney fees, and settlement costs. So it has some merit, but the outcome I don't think would be positive, and it would lead us to the possibilities of lawsuits that we as Pierce County cannot afford. So I would not be, I would say no to this proposal.
Commissioner Roki?
Thank you, Madam Chair. Commissioner Rogi, District 3. This office, I believe, is duplicative, and an unaccountable monitor of the Sheriff's Department, to me, is unacceptable. To claim transparency when the first move in the language in the charter is that they carve itself out from transparency laws, and I don't even know if that's even legal. I don't know if a government department can legally exempt themselves. So, in my opinion, and I've heard from my community, they love the sheriff. They elected the sheriff. We already have means to deal with a sheriff that we don't want. We can recall them. We can. There are several internal investigation departments. I said it before, and I'll say it again, that this feels like a local 5974 where they're trying to garner control over the sheriff's office. It's not independent because it's another department under the executive, creating another department under the executive. So, and I heard last week the cost in Spokane is $1 million for an ombudsman. We have internal mechanisms. The public can call the sheriff's office directly. There are so many ways that the sheriff's office is held accountable that I think that it does not belong in the charter, and it is overreach and creates the possibility of fishing expeditions and political abuse, costs and public record exemption abuse, potentially resulting in a secretive, unelected power center. So that's why I'm going to vote no. Thank you.
Commissioner Layton?
Thank you, Madam Chair. Commissioner Layton, District 7. I'll be brief, given how long we'll be going tonight. I think transparency is something that can be said about this office. I think accountability is something that can be said about this office. The attempt to have oversight over the very folks who are there to serve and protect us is really important. And it's something that I've always believed in, something that I appreciate having citizens commissioned when it comes to this in the city of Tacoma, for example. And when we think about, it's not just about one man, one sheriff, it is about public safety in general. And so when we think about what we have entrusted in them, we certainly should be able to have the ability to have oversight into a lot of these activities as we move forward, and so I'll be voting for it and encourage you to as well. Thank you.
Commissioner Rohr? Commissioner Rohr, District 6. So I have a question, and then I'm happy to speak to the amendment. So I guess it's a point of maybe legal clarification. I believe the amendment to the amendment that was adopted had some language revising it, talking about that. What is it? It's ombuds is required. Specifically, it says production of records, witnesses, information to the ombuds is required to the same degree as law enforcement or criminal justice agencies, and is not subject to the Public Record Act procedures or exemptions. And so my concern is not with accountability or appropriate oversight. My concern is that this language is too broad and legally sensitive for the charter. Sheriff records can include active investigations, victim and witness information, personal records, criminal history records, internal investigations, confidential law enforcement information, and other protected material. Those records are governed by the state and federal law. A county charter should not appear to bypass or rewrite those protections. If an ombuds office is created, record access should be established through implementing ordinances adopted by the county council after public process, legal review, labor and operational review, and clear confidentiality safeguards. Has that issue been addressed? I guess it's a question for legal and maybe the sponsors of this amendment. And I do have language that I could work with you on to clean that up. Can it be bypassed, the Public Records Act?
So I guess, I don't know if our legal folks have anything they'd like to share tonight, or
Well, this has been a topic that's been discussed quite a bit on this proposal, is how to comply with the Public Records Act, and I believe that the way it is currently phrased, the intention is that just as the Sheriff's Department has their own records, the records would maintain that status even if they are produced to the ombuds. I think that's the intention. How that'll play out, we'll see.
thank you for that legal clarification. So, Commissioner, did you have more?
So I might reach out to, I don't know, Commissioner again, and maybe offer, who is it? I would offer a friendly amendment to improve that language.
So if you're wanting to make an amendment tonight, no. If not, then it would be, if it makes it onto the hopper, then we could look at language changes then.
Yeah. So on C30, I support accountability, transparency, public trust, and law enforcement, but I do not support placing C30 in the county charter. That is something that our county council, they have talked about. They've never acted on it. I know they have a public safety committee. I think the chair of the committee was here and spoke to the issue as well. C30 would create a new executive department or sheriff's ombuds with authority to oversee the sheriff's department, investigate complaints, subpoena records and witnesses, publish findings, and refer matters to legal or investigatory authorities. That is a significant new investigative layer over an independently elected sheriff by an unelected body. Subpoena power is serious. It moves this office beyond advice and review. It gives it a formal authority to compel records, information, and testimony. That kind of power should be carefully defined before placed in the charter. There are already multiple accountability systems in place, including internal investigations, county council oversight, which I think Commissioner Rogi, you were speaking to protections already in place, but the county council is also one of those. Their oversight is also key in terms of accountability. Council investigative authority, prosecutors, courts, civil litigation, the state auditor, the Criminal Justice Training Commission, independent deadly force investigations, and the State Office of Independent Investigations. Washington has also made major law enforcement accountability reforms since 2020. So my concern is not whether accountability matters, it does. The concern is that C30 creates a permanent new office with broad investigative and subpoena authority without clearly resolving overlap of all these different groups. Confidentiality, so it doesn't clearly address that. Due process, labor issues, active investigations, public release of sensitive information, cost, staffing, or implementation. Pierce County is also facing financial shortfalls. Before creating a department in the charter, we should know the cost, how it is staffed, where the funding comes from, and how it affects existing services. The charter should establish the basic structure of government. It should not pre-design a complex oversight office without unresolved legal, operational, and fiscal questions. Pierce County wants to consider a sheriff ombuds office that belongs in the county council process through ordinance with public input, legal review, fiscal analysis, labor review, and implementation planning. And so for those reasons, I oppose C30. Accountability does matter, but this level of operational detail does not belong in our charter. It belongs in an ordinance. And I would like to speak to one of the legislative oversight structures that is now in place. So this last legislative session, Senate Bill 5925 was passed, and that strengthens the argument that the Sheriff Ombuds proposal creates another investigative and legal layer. What Senate Bill 5925 does, which is now in law, it gives the Washington Attorney General new authority to issue civil investigative demands or CIDs. What is a civil investigative demands? What can those require? Under Senate Bill 5925, the Attorney General may require documents, records, written answers to questions, oral testimony. What it matters for sheriff oversight, Senate Bill 5925 allows the Attorney General to use these civil investigative demands when investigating possible violations of the United States Constitution, the Washington State Constitution, certain law enforcement related Keep Washington Working Act provisions, possible violations, I'm going to continue, of wage laws, the Washington Law Against Discrimination, the City and County Jails Act. And that matters because the Sheriff's Office and County Jail could potentially be involved in issues related to jail corrections, detainee treatment, constitutional rights, discrimination, law enforcement, immigration-related restrictions, and civil right compliance.
Commissioner Rohr, that's 10 minutes.
Thank you.
Commissioner Larry?
Thank you. A lot of what I was going to say has already been said. Just trying to skim through my notes here. The ombuds would not be elected. Only could be removed for cause. That requires a 2/3 vote of the council. In practice, removal could become very difficult. We've talked about accountability and the forms that it already exists. Sheriff is elected, and Commissioner Rohr mentioned all the other elements. This creates another layer of bureaucracy without demonstrating that the current systems are incapable of addressing misconduct. It creates a powerful unelected official who can investigate, subpoena, and work basically at their will, while being largely insulated from the voter. Control would be difficult, and removal would be very difficult. Oversight should be independent, but it must also be accountable. And I don't see where this ombuds is as accountable as we're trying to hold our elected officials.
Exactly.
So I will be a no vote on this. Thank you.
Commissioner Lance?
Thank you, Martha Lance, District 7.
Yeah, well said.
As one of the co-sponsors of this, I just wanted to address a few items about it and urge that we move it forward for continued consideration. First, this is a complex proposal. It's complex because it needs to be. It's written in a way that has numerous checks and balances written into it about the appointment process, about the removal process, about how the person is selected to head up this office. Council gets a say in it. The sheriff's office gets a say in it. The sheriff's unions get a say in it. It's intended to be created in such a way that it does insulate itself from the political process. Various stakeholders and various interest groups and the very elected officials on the county council get to weigh in on how to appoint this person or which person should be appointed. With regard to the other resources, I guess, or other opportunities to perform the same kind of work, the difference here is that this is an objective, truly independent place. That's the intention, that it be set up as something that's cordoned off from law enforcement, a place where people who have concerns can come and not be worried that the law enforcement agencies are investigating themselves. So it adds a level and a layer of independence and accountability. That's what it's intended and designed to do. And I would add that it does seem to be responding to a number of things that we've heard from community members who have spoken and who have provided written comments as well. And it's truly intended to be agnostic to whether the sheriff is elected or appointed. It does not turn on that. It's not about this particular sheriff. It's not about any sheriff in particular. It's intended to be what it is described as, is an objective, professional avenue to address concerns and complaints coming from the public. With regard to the public records concerns and the transparency, I would echo what the deputy prosecutor said. The intention here is not that these records are exempt from the Public Disclosure Act. The intention is that the Sheriff Ombuds Office be treated as another law enforcement agency, which would allow records to be provided to it, absent redactions and absent withholdings. The Sheriff Ombuds Office itself is a public entity. It is subject to the Public Disclosure Act and all the restrictions and redactions and protections that exist over those records. Should they be requested from the Ombuds Office, they would be subject to the Public Disclosure Act. They would be redacted. If the records relate to active investigations, they can't go out. All of the things that cover law enforcement in the Public Disclosure Act apply completely, or intended to apply completely to the records once they're held by the Ombuds. The language is intended, however, to require that the law enforcement agency fully participate in providing records and access to records as they are requested, and that they're not provided to the Ombudsman in a redacted manner or withheld for reasons that they would be withheld if requested by the public. So I wanted to correct that misimpression. That said, the offer to continue to refine this, of course, would be welcome, but the reasons that have been discussed, again, by members of the public and by the sponsors, I think advocate to advance this to next steps for further consideration. So thank you.
Commissioner Ryan Kelly.
Thank you, Madam Chair. Commissioner Ryan Kelly, District 4. I'll keep my comments in this brief. The other thing that I've worked on extensively over the last several years outside of housing justice is criminal legal reform, including a multi-year campaign to create the non-police crisis response team in the city of Tacoma. And I'm not saying that not to toot my own horn, but through the process we learned a lot about litigation. And there are many reasons I support the Ombuds Office. And honestly, litigation and money is not top among them because I really believe in people's freedom and rights. However, I would make a call to the fiscal conservatives on this body that an Ombuds Office is a profoundly significant cost-saving mechanism, not only around litigation and settlements of litigation with people involved in wrongful death or mistreatment, harassment, all other types of things with officers of the law that could be resolved through the ombuds process rather than through litigation, but also with insurance. And I don't know the exact amounts. Some of us were trying to look that up this week on what the county pays for insurance, but one of the biggest determinants of county insurance costs are criminal legal lawsuit settlements. An ombuds office, even at Spokane's at $1 million a year, that is nothing compared to often a single settlement. And there are many, many settlements that come in different jurisdictions all the time. I've been around and actively involved in some of those, and I can say it's not pretty. So I think anyone on this commission that is a fiscal conservative, an ombuds office should make perfect sense to you. That's all I gotta say.
Commissioner Likens. Thank you, Madam Chair. I want to echo the comments from Commissioner Lance and Commissioner Rydell Kelly. I agree with the transparency and the legal and the cost similar to the juvenile justice reform. When you have these mechanisms in place to hold people accountable, it decreases your liability. And really briefly, just to put into perspective, I'd like to bring up ordinance number 2023-13 of the county. This occurred in 2023. It was requested by the county executive at the time in 2023, the prosecuting attorney, and the sheriff. It was sponsored by council members Herrera and Morrell. And I just want to read their reasoning on why they wanted to establish this board that they were putting forward. The existing system of investigating complaints of law enforcement uses force, discrimination, harassment is not subject to independent review, whereas it is in the public interest for residents of Pierce County to have an independent, unbiased mechanism to fairly review complaints and investigations concerning law enforcement and conduct, and whereas the county believes the establishment of a civilian review board to conduct preliminary reviews of complaints, to issue recommendations on investigative findings, and to publish annual reports that would add transparency and confidence to the process of policing. Those are the words sponsored by two of our current county council members and requested by the sheriff and the administrator. Thank you.
Commissioner Rohr? Commissioner Rohr, District 6. Thank you for bringing up the 2013 ordinance and the work that was brought to the council. And I don't know all the details, but I do know that those commissioners withdrew their names from that proposal after further reviewing it, discussion. I don't know because I wasn't there. And we could get more feedback, but my understanding is that they withdrew that support.
Alright, so I believe that concludes discussion then. Alright, so what that brings us to then is the vote for our motion to C30, Sheriff Ombuds, on page 54 of your packet, onto the hopper for final consideration. Again, this will be a roll call vote, as all second reading votes are. So, clerk, over to you.
Lisa Boyd,
Yay.
George Consuelo,
Yay.
can we say aye or nay? There, thank you. Mason Fletcher,
No.
Kate Kinn,
Aye.
Sharon Hennick,
No.
Caleb Heimlich,
No.
Elizabeth Herrera, no. Billy Joe Hetherington,
Yes.
Jake Hunter,
Yes.
Martha Lance,
Yes.
Justin Layton,
Aye.
Brenda Likens,
Aye.
Brenda Molesky,
No.
Jerome O'Leary,
No.
Holly Roby?
No.
Susanna Rohr? No. Devin Randall Kelly?
Aye.
Troy Surratt?
Aye.
Jen Reed Strickling?
Aye.
Judson Willis?
Nay.
Kelsey Barons?
Aye.
Alright, I have 12 in favor and 9 opposed.
Alright, so that motion passes, and C30 will move on to the hopper for final consideration. Next, we move on to C39, Public Safety, Accountability, and Transparency on page 57 of your packet. Commissioner Malowski, do you have a motion for us? Commissioner Malowski?
Madam Chair, I move adoption of C39 to go proceed to the hopper.
I have a motion to move C39 onto the hopper. Do I have a second? Second. Second from Commissioner Roby. So on to discussion of C39. Commissioner Crenlick, it is your motion. Would you like to speak to it?
Well, yeah, we have heard from many members of the public that we need more law enforcement. I can speak to this personally. My car was stolen from my driveway in Graham. When I was speaking to the county sheriff deputy, I was told there are, at any given time, 2 deputies on the clock from 224th and Graham all the way to Ashford. And that level of law enforcement is just simply unacceptable. And so we need a dedicated funding source for more deputies in the Pierce County Sheriff's Department. So that's why I support this proposal. Thank you.
Additional discussion. Commissioner Roby?
Commissioner Roby, District 3. I support the core intent of this proposal, charter amendment on public safety, accountability, and transparency, ensuring independent review, clear public reporting, funding stability, and ongoing coordination across our public safety system is essential for building and maintaining public trust. These principles are timely and important, particularly around protecting dedicated revenues like the Justice Fund while allowing responsible flexibility with appropriate oversight. That said, the current version is too long and prescriptive for the charter. With 9 sections that deliver into detailed processes, it reads more like legislation. I think this proposal merits more consideration and moving it to the hopper where we can amend the proposal to a higher level statement that captures the key goals, independent review, transparency, and performance, funding stability, and safeguards. This is a sound amendment. It simply needs to be elevated to the appropriate level of the charter amendment. I will commit to working with Commissioner Molesky should this move forward, and I recommend it does.
Commissioner Layton?
Thank you, Madam Chair. I'll be a no vote on this. This amendment doesn't create new funding. It doesn't create additional revenue. In fact, as we heard early on in our process when several of our executives in their work, the vast majority of taxes that go towards the county, including those of us who pay those taxes in incorporated parts of our county, go towards public safety. It's already being done. And a lot of the arguments we heard tonight about this doesn't belong in the charter, this is policy, this is legislation, we're not legislators, a lot of this is that. And so I will not be supporting this amendment moving forward. Thank you.
Commissioner Rohr?
Commissioner Rohr, District 6. I support transparency, accountability, and stable funding for our public safety. However, I have concerns with this proposal as written. The explanation goes farther than the actual language. Some of the promise protections are not clearly written into the amendment, and it is unclear what this proposal would add beyond what's in place. Before adding language into the charter, we should be clear about the legal effect, how this amendment relates to existing law in the current justice fund ordinance, and whether it would appropriately limit the budget authority of future councils. For those reasons, I still have concerns with this proposal as written.
Commissioner Likens?
Thank you, Madam Chair. I just want to concur, I'll keep my comments brief, with Commissioner Rohr. I do believe, we do need to look at staffing, and I'm sorry that happened to your car. And I know there are concerns out on the Cape Peninsula and District 7 in particular with some recent tragic incidences. And I think it's important for hopefully the County Council to continue to look at this, but for the reasons that Commissioner Rohr and Commissioner Rogi also brought up, I have concerns about the length of it and the policy, so I will be a no vote. Thank you.
Commissioner O'Leary?
Thank you, Commissioner O'Leary, District 1. I will also be a no vote based on the way it's written. And if we are going to put a recommendation list in front of the council, I would recommend that this be one of the elements that we discuss putting there, because I do think additional funding is necessary. I think we're grossly understaffed in East Pierce County. I'm not familiar with so much with the peninsula, but it sounds like it could be consistent. And we just have to do a better job. So I think it should be a priority. It just isn't a charter element in my mind. Thank you.
Seeing no additional discussion, we will move on to a vote to move C39, Public Safety, Accountability, and Transparency, onto the hopper for final consideration. We'll do a roll call vote, so over to you.
George Consuelo?
Nay.
Mason Fletcher?
No.
Kate Ginn?
Nay.
Sharon Hannick?
No.
Caleb Heimlich?
Aye.
Elizabeth Rivera?
No.
Billy Joe Hetherington?
No.
Jake Hunter?
No.
Martha Lance?
No.
Justin Layton?
No.
Brenda Likens?
No.
Brenda Molesky?
Aye.
Jerome O'Leary?
No.
Holly Rogie?
Aye.
Fujana Rohr?
Yes.
Devin Rydell Kelly?
No.
Troy Surratt?
No.
Jen Marie Strickling?
No.
Judson Willis?
State?
Sorry, that's Kane. Lisa Boyd?
No.
And Kelsey Barons?
No.
Right, I have 4 in favor, 16 opposed, and 1 abstention.
So that motion fails, and that takes us on to O1, Financial Procedures Modernization, on page 59 of your packet. There's actually not a sponsoring commissioner because this came from another elected official's office. So is there a commissioner that is interested in providing a motion to sponsor O1? Or not to sponsor, but just to move O1 onto the hopper for final consideration.
Madam Chair, I move to move proposal 01 to the hopper for final consideration.
I have a motion, do I have a second?
I'll second.
So we have a second. So on to discussion of O1, Financial Procedures Modernization, on page 59 of your packet. Commissioner Starr, would you like to speak to your motion?
That's right, I forgot about that. Commissioner Spratt, District 5, we invited elected officials and other staff of Pierce County to provide their expertise with regards to modernizing or revamping sections of the charter, and the finance department through Julie DeMuth did a really excellent job, I think, in doing precisely that for the article that is related to her expertise. I think the set of revisions within this proposal is concise. They are well considered, and I think they would be beneficial to the county should they be adopted by this body and by the voters, and therefore I encourage all commissioners to support this amendment.
Additional discussion on 01. So I have an amendment to the amendment.
So just,
And I'd like to
yes,
move.
you do have, sorry, yeah, on page 66 of your packet.
I'd like to move my amendment.
You'd like to make a motion to amend 01.
Thank you, Madam Chair. So the page
Second.
60
Okay, thank you. Now, can you please speak to your motion?
So I am offering, do you want me to just speak to what the amendment does, essentially? So if you look at the amendment, bear with me. I am updating language where the CFO prepares and proposes the budget. I'm updating that language consistently through that article, and then I'm also updating that the chief financial officer, and I asked clarity on this point at the last meeting from Director DeMuth. Is the chief financial officer a new position separate from the Department of Finance director? And she said, no, they are the same. So to provide additional clarity, I'm doing that with this language that says chief financial officer, the executive shall appoint the director of finance because that's the established department in ordinance. So the director of finance, subject to confirmation by the county council, who shall serve as the chief financial officer of the county for purposes of this article, who shall be responsible for the financial administration of the county, including preparing and providing financial forecast revenue estimates, budget information, and reports to the executive and the county council on the actual revenue and expenses of the county in accordance with state law in this charter. And then there's also an update where the executive's office struck out that, well, I'll read the language. So in section 6.5, consideration and adoption of the budget, in section 2 it says the appropriation ordinance adopted by the county shall not exceed, and I changed it to estimated revenues and reserves as prepared and proposed by the chief financial officer for the next biennium for each fund, including surpluses reserves, but the council may increase the amount of estimated reserves contained in the budget presented by the executive by re-estimating the amount by a motion passed by a minimum of 5 affirmative votes, and that was crossed out in 01. I put that back into the charter as it stands, and so that the legislative body would still retain their authority. So that's what the motion does.
Alright, so now discussion on the motion. So I saw.
Point of just clarity if I can. I believe there's a Scribner's error. There's 2 D's. And I didn't win any spelling bee growing up. And I'm very dyslexic of those who know me for many years. But I believe in that what you just read off, there exceeded D and then D. I would say it's Scribner's error. Make sure it moves forward.
Thank you. Can I speak to the amendment?
So were you? Oh, okay. So if you can be very.
I'll do my best.
Okay.
She already moved and seconded.
Well, I spoke to the language.
Yeah, motivation.
Sorry.
So, Commissioner Rohr, if you can be very, very brief, and not, yeah, because we.
So my amendment keeps the goal intact of 01. The language is clearer and preserves the council's legislative role in the budget process. With me. So I want to be clear what this amendment does and does not do. It does not allow the council to adopt an unbalanced budget. The charter would still provide that appropriations may not exceed the estimated revenues and reserves. It does not remove professional forecasting from the process. The CFO would still prepare and propose estimates, provide reports, and advise the council and the executive. What it does is preserve the council's existing legislative authority to deliberate and, when appropriate, re-estimate revenues by a motion passed by a minimum of 5 affirmative votes, or create additional revenue sources through the public legislative process. So the 5-vote threshold remains, the balanced budget requirement remains, public hearings remain, the council's responsibility and accountability remains. So the language that is currently in our charter is fairly identical to 4 other charters in our state, where they retain the legislature retains the authority over the budget. The executive's office, whether it's the CFO or the finance department, informs the budget. So in Snohomish County, the charter follows a very similar process. The executive proposes the budget. The council may amend motions. Appropriations may not exceed estimated revenues. Snohomish County Council may increase estimated revenues by re-estimating them through a supermajority motion, by using reserves differently, or by creating additional revenue sources. Whatcom County is similar. King County is also similar. It uses a little bit different principle. King County has an independent office of economic and financial analysis that provides objective revenue forecasting and budgeting. Those professional forecasts inform the executive's planning, the proposed budget, the council's adopted budget. But the elected county council remains the legislative authority that adopts the budget. And I'll just rest it there. Thank you.
Thank you. Okay, on to discussion. So first we have Commissioner Lickens.
Thank you, Madam Chair. I appreciate the intent in your amendment. I do have a little bit of concern. And my concern is that the financial experts present the budget and the estimated revenues, and that having a council be able to re-estimate that amount by motion, and granted it does take 5 members, a supermajority, so ideally bipartisan participation. I am a bit concerned that people who don't have the financial training necessarily are going to be re-estimating what could be in the budget. And I have concerns about how they do that, going into extra reserves. I just pause on that. I know it is in other charters, and it sounds like in the King County one they use an unbiased board to go through that, but I'm hesitant to approve and will likely be a no vote. Thank you.
Commissioner Roby.
Thank you, Madam Chair. Commissioner Rogi, District 3. As written, I definitely support this amendment because it appropriately limits the Chief Financial Officer's authority over the budget process in ways that reinforce the elected County Council's ultimate legislative authority. The County Council is the one who authorizes the budget. My main concern with this initial presentation was that the Chief Financial Officer put into a potential charter proposal that they have more authority over the council and appoint a position working under the executive. Again, executive control. And that concerns me. So by constraining the CFO's role, the amendment helps prevent any appointed administrative position from exercising undue influence over fiscal priorities as approved by the county council. Careful scrutiny must continue to be applied to the final language, though, because any amendment must limit the CFO, who is an appointed position. We must limit the CFO's authority, and the council must retain full budgeting authority to ensure separation of powers. Thank you.
Vice Chair Lentz.
Thank you, Michael Lentz, District 7. I support the amendment offered by Commissioner Rogie. However, I would just like to point out that the original 01 proposal is not markedly different. I appreciate that Commissioner Rogie moved language around, but the initial 01 proposal is contained at page 62 in the packet, and I would disagree with Commissioner Rogie's, Commissioner Rogie, who just spoke, with her presentation of the original 01, because if you look at page 62, what original 01 said is current language, the appropriation ordinances adopted by the council shall not exceed the addition was shall not exceed the chief financial officer's estimated revenues of the county. Everything else remains the same, including that the council may increase the amount of estimated revenues contained in the budget presented by the executive. It did not take away the council's ability to increase the amount of estimated revenues. In fact, it made it easier for council to do that by removing the 2/3 requirement. The contingency there was that in order to increase the amount of estimated revenues, the council had to do that with the certification of the chief financial officer that additional revenue is available. And if we turn to Commissioner Rogie's amendment, I think it does the exact same thing. Commissioner Rohr, I'm sorry. Sorry, you were right the first time, Chair. If we turn to Commissioner Rohr's amendment, I think it does the same thing. It states it a little bit differently and more consistently with the use of the title Chief Financial Officer throughout. But the amendment in that same section, and I'm looking at page 67 in 6.502, the amendment says that the appropriation ordinances adopted by the council cannot exceed the estimated reserves and revenues and reserves as prepared and proposed by the chief financial officer. So we're still talking about capping the estimated revenues and reserves that can be spent with what the chief financial officer has provided the council. And what Commissioner Rohr's amendment does is to then say that the council can re-estimate that amount, but still capped at what they've been informed by the chief financial officer is available to be spent. And they can do that by a 2/3 vote. So I'm in favor of the amendment. I don't think it changes up anything, and it actually does give the council the 2/3 majority over a spending change to spend additional revenues. But again, it remains capped by what the chief financial officer tells them that they have to spend. So I think it honors that council holds the power of the purse, that the budget and spending decisions belong to the council, but those decisions are being made in an informed fashion, which was actually part of the original proposal from the beginning. So with that caveat, like I said, I am in favor of the amendment, and again, for the same reasons as I've been in favor of other amendments, that if we're improving and getting more support around a proposal by an amendment, that's what we should be doing.
Seeing no additional discussion, we will vote on the amendment to 01. So, all in favor? We'll do a card. All in favor of the amendment to 01 as is shown on page 66 of your packet, please raise your cards. Count all 21. Great, so that motion passes. So now we are back to discussion of moving 01 financial procedures modernization as amended onto the hopper for final consideration. Commissioner Rohr.
Just a point of clarity or just information. So I learned that on April 28th, 2026, the county council, and I haven't had time to look at it, passed an ordinance and they renamed the Department of Finance. And it is now the Department of Finance and Enterprise. So we might update 01 so it's accurate. And it also, in that ordinance, it speaks to the CFO, which is new language as well. So anyhow, I thought I would bring that to everyone's attention. Thanks.
Commissioner Rogi.
Thank you, Madam Chair. Commissioner Rogi, District 3. And to Commissioner Rohr's point, putting this kind of information in the charter with regards to departments and positions is inappropriate because the executive and council do need flexibility to be able to adjust to the needs of the county. So even as amended, the main reason I do not support this amendment proposal to the charter is because of what appears to me as a conflict of interest. This proposal was submitted by the current Director of Finance, which she confirmed is the same position as the CFO, and she put detailed provisions regarding her own position directly into the county charter. Embedding her position in the charter is not neutral clarification, so such actions to me raise serious ethical concerns. So I will be voting no. Thank you.
Any additional discussion?
Does anyone else want to speak?
Well, is anybody else got anything to say? See nothing. Commissioner Rohr, you have your last.
Commissioner Rohr, District 6. I'm going to be supporting this amendment. I appreciate this, the support of the amendment to the amendment. I've also worked with Julie Demuth at the county. She's an incredible professional. I've worked alongside her counterparts in the past. I think this is just, at this point, because of the amendment, it is more cleanup language. There is some interesting changes in the amendment. It talks about the 6-year outlook. It strikes out some language. And I'm not sure that they were doing that. And so, yeah, I'm just going to be supporting 01 and would urge you to do the same.
Seeing no additional discussion, it's time to take a roll call vote on 01 as amended.
Mason Fletcher,
Abstain.
Kate Ginn,
Aye.
Sharon Hannick,
No.
Caleb Heimlich,
No.
Elizabeth Herrera,
No.
Billy Joe Hetherington,
Yes.
Jake Hunter,
Yes.
Martha Lance,
Yes.
Justin Layton,
Yes.
Brenda Likens,
Yes.
Brenda Molesky,
No.
Jerome O'Leary,
No.
Holly Rogie,
No.
Lujana Rohr,
Yes.
Devin Rydell Kelly,
Yes.
Troy Surratt,
Yes.
Jen Marie Strictly,
Abstain.
Judson Willis,
Nay.
Lisa Boyd,
Yes.
George Consuelo,
Abstain.
Kelsey Barron,
Aye.
I have 11 in favor, 7 opposed, and 3 abstentions.
So that passes, and O1 will move on to the Hopper for final consideration.
Madam Chair,
Yes, Commissioner Leary.
could we take a 5-minute break?
Is there any objection to a 5-minute recess? Hearing none, we are recessed until 9:46.
Yeah.